Welcome to the Town of Avon Board of Zoning Appeals meeting. If you're interested in having a copy of the agenda or the staff reports, they are available on the tables to the right of the audience. This meeting is being recorded for the public record. Because of this, we request that personal conversations are kept to a minimum and cell phones are set to vibrate with any phone calls taken outside of the chambers. If you are interested in commenting during any public hearing, please sign up on the sheets located on the tables to the right of the audience. When your name is called, please step forward to the podium, state your name and address for the record. Please address your comments to the board and not to staff or the appellant. Your comments should relate directly to the case at hand. We do understand that there may be several persons who wish to speak. The chair may therefore impose a time limit for each person. Federal law requires that the town make available to all attendees a Title VI public involvement survey. These surveys are on the table to the right of the audience. Members of the public who wish to complete this survey may do so and place them in the designated area. If because of a disability, any person in attendance needs assistance or accommodation to fully participate in this meeting, please notify staff. Thank you for your assistance in facilitating a respectful, fair, and timely meeting. Again, welcome to our meeting. Please stand for the Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Paul Guckenberger.
Here.
Ann Inman. Here. Catherine Ransberg. Here. Marcy Tashler. Here. Marcus Turner.
Here. First on the agenda is the approval of the minutes from July 17th, 2025. Did anyone have any questions, comments, corrections? And if there are none, we'll entertain a motion.
Actually,
June 17th.
the number underneath there.
Okay.
I'll make a motion to approve the minutes of June 17th.
I'll second.
We have a motion by Mrs. Inman and a second by Mrs. Ransberg. Any discussion? All in favor say aye.
Aye.
Anyone opposed? Meeting minutes are approved. Next item is request for continuances or agenda modifications.
Thank you, Chairperson Turner. So the first two petitions on your agenda, SE 2502 and VAR 2503 for 7 Brew at Shiloh Crossing, are being withdrawn by the petitioner. With the plan they filed, they would have needed a variance for a bypass, for a deficient bypass lane. They had submitted a revised site plan a couple of weeks ago that would have been compliant, and so the VAR case was already going to be withdrawn. We anticipated the special exception going forward when we published the staff report, but a few days ago, the petitioner indicated that their client still wanted to revisit the site plan, and so they requested to withdraw the special exception, and they anticipate that they'll refile in the next couple months once they've come up with a site plan that is satisfactory to their client. So recapping, SE 2502 and VAR 2503 both being withdrawn, and that should just require your acknowledgement.
Very good. Thank you. Public comment. Does anyone wish to address the board? And with no one coming forward, we will close public comment. We have no old business. We will go right into new business. And our case for this evening is VAR U 25-02-137 Production Drive Childcare.
Thank you again. This is a request for a variance of use of UDO 3.2, which is the permitted use table, to allow for childcare use as a primary use in an I2 district, I2 being in the general industrial district. The property is located at 137 Production Drive, just south of US 36. It's a little less than 1 acre. And you can see it on the map here on the east side of Production Drive. This is a look at the front of the building facing west across Production Drive. That's a view facing the opposite direction. Sorry, that was facing east, not west. This is facing west from the front of the property across Production Drive to the abutting industrial properties. That's facing north along Production Drive towards US 36 from in front of the site, and then that's facing south along Production Drive from in front of the site. Production Drive, just south of this site, turns west and then terminates a little farther back to the west. These are a couple of photos that were submitted by the petitioner of the outdoor play area that's been constructed along the south side of the building. Excuse me, this is the site plan. So this is the building here, and the childcare operation would take this portion here. There's parking out front and other portions. I'm not sure about both portions of the building. There is an auto repair business that's operating in part of the building as well. So the petition indicates that this use would occupy about 3,700 square feet of the existing 13,000 square foot commercial building, with the outdoor play area that I showed you in the photos, comprising about 600 square feet along the south wall of the building. So while childcare use is not a permitted use by right in I-2, it can be permitted by a grant of special exception as an accessory use to another industrial permitted use in any of the industrial districts. So we would typically look at that as a situation where there's an industrial user, just say, for example, across the street from this property is Harlan Bakeries. If, as a permitted industrial use, they wanted to run a child care for the benefit of their employees, they could do that on their site. Potentially, they would need to apply for a special exception, but the ordinance envisions that that can be an appropriate use in an industrial district. So we do see that the UDO contemplates the need for and the appropriateness of a child care facility in an industrial district. And we don't think that the proposed child care facility would interfere substantially with continued industrial use of the surrounding industrially zoned properties, and that it could potentially be a benefit to workers in the industrial district. So for a use variance, you have 5 findings that are required. The first, that it's not injurious to public health, safety, morals, or general welfare of the community. The second, that the use or value of adjacent areas would not be affected in a substantially adverse manner. The third, that the need for the variance arises from some condition peculiar to the property. The fourth, that the strict application of the terms of the ordinance would constitute an unnecessary hardship if they were applied to the property. And finally, that it doesn't interfere substantially with a comprehensive plan. I'll talk about each of those. If I can just back up to give you a little bit of history on this. So as I understand, the petitioner had called the town offices prior to signing a lease and moving forward with trying to operate this use. And I know firsthand from looking at our Beacon website that hosts our GIS, that provides both to staff and to the public all of our property and zoning information, that the addresses that are assigned on Production Drive are not, they're not necessarily consistent with what's out there. And some of the parcels don't have an address assigned to them, such as this one did not. So as I understand it, the applicant, the operator of this facility, had called the town and had inquired about this address and what they would need to do from a zoning standpoint in order to operate a childcare facility there. When town staff couldn't find that address when in searching in the beacon system, town staff interpreted that that address was not located in the town of Avon and instructed the applicant or operator to contact Hendricks County in the belief that it was in must have been in an unincorporated portion of the county. So my understanding is that the applicant, and they can obviously attest to this firsthand in their testimony, but my understanding is they contacted the county, who said that we don't regulate that property. Would have made sense that they would have maybe told them it was in the town of Avon if they found that, but they told them they didn't regulate it. And so then our understanding is that the applicant believed that they were good from a zoning standpoint and moved forward with signing a lease and doing whatever they needed to do to the property to operate their use. The potential use came to the attention of the town when there was a complaint made after the outdoor play area was first established on the west side or the front of the building, close to Production Drive. The town received a complaint. Somebody was concerned with the play area being out near the roadway. The town's inspector went out, checked on the property. It appeared that they were either operating or working towards opening for this type of use. So they were cited for a use that's not permitted by right in an industrial district. At that point, they came in and talked to town staff. We explained the situation, that it was located in the town, that it was zoned I-2, that it didn't permit that use by right, and that their remedy would be to file for a variance of use, which they promptly did at that point. And I believe they need to still, they need to have a license approved by the state that regulates childcare facilities, but I don't believe they can get that approval until they have demonstrated that they meet local zoning for the use. I believe they would also have to have a fire inspection by the Avon, Washington Township Fire Department to meet those codes. I believe I was told by our building commissioner that they've had an inspection and they have some corrections that they'll need to make. And I don't have all the details on that, but as I understand, those are all things that can be worked through. They're not major issues that would require major renovations to the property. So that's how we got to the point we're at today. So in going through the findings, the first finding that it not be injurious to public health, safety, morals, or general welfare. Essentially, as I mentioned, how they operate the facility is regulated by state statute, and the state will require inspection and licensing to make sure that they operate that in a safe manner. So if they can meet the state requirements, in addition to fire code, which is an ongoing thing they'll have to address, we don't believe that a childcare facility here would be injurious to the public. We also don't see a reason to think that it would negatively impact the use or value of adjacent properties, which is your second required finding. This building was built prior to incorporation of the town, so prior to the town being incorporated and passing a zoning ordinance and zoning this industrially. Looking at the assessor's property card, it shows this building as a commercial building rather than an industrial building. I'm not sure on all the history of what uses have been in here. The auto repair that I mentioned, that could be considered a commercial or industrial use. It's permitted in both commercial and industrial districts. Looking at the front of the building, it looks a little maybe closer to an office type building than a typical industrial facility. So staff thinks it's reasonable to say that it could be a condition peculiar to the property that it was built prior to the town's zoning, and that the building may be more conducive to non-industrial uses, and therefore it could be appropriate to grant a use variance to use the building for a childcare use that it might be more conducive to than a permitted industrial use. And therefore also strictly applying the terms of the UDO that would require other industrial uses to be in here instead of a childcare facility could be considered an unnecessary hardship for a building that predates the town and its zoning ordinance. So those are the third and fourth required findings. The fifth finding being that it doesn't interfere with the comp plan. Again, although the I-2 zoning doesn't permit a childcare facility by right, we think that it could be considered complementary to the adjacent uses. It could be used by workers of the other industrial properties to take care of their childcare needs while they're at work. And we don't think it would interfere with the continued use of those adjacent properties for permitted industrial uses. So for those reasons, staff is recommending approval because we do think the 5 required findings would be met. We would just recommend approval subject to substantial compliance with the site plan on file. And with that, I'd be happy to answer any questions that you may have.
I just want to clarify, they are not currently operating in the building, correct? Or are they currently operating in the building?
That would be a question best addressed to the petitioner.
Okay,
I don't believe they're operating because they're awaiting their state license. I'm not aware of whether they have some provisional permission that would allow them to operate, but I'm assuming they're not operating, but that would be a
I
question
just wanted to
for
make
them.
sure I didn't mishear something, so thank you.
And have the address issues been resolved?
I believe that we do have the 137 address assigned there now, right? Yep. Correct. Yes.
Are there, and when you were describing this, I got the impression there's multiple uses of this parcel.
That's correct.
So is this variance for going to cover all the uses of that parcel?
Well, I don't know exactly what is in each of the other portions of the building. As the site plan shows here, the daycare would take this portion of the primary building. There's also this northern portion and this eastern portion that the daycare would not use. I don't know if both of these are used by the existing auto repair business or if one of them might be vacant. I know there's auto repair going on back here based on, seeing vehicles back there. And this,
So
there's also 2 other buildings on the site. The site plan obviously doesn't indicate. I don't know if the petitioner can shed more light on that, but the auto repair use is a permitted I-2 use. So there would be no need for this variance to address that use.
well, so help me here because it sounds like we have multiple primary uses of this parcel. So I'm trying to understand the variance, if it applies to the entire property, to a specific piece of property, which I didn't think that is how a variance works. And then do we have multiple primary uses, which isn't that again, do we have to address that? Can you have multiple primary uses on one property?
We've had cases before where when you had multiple primary uses, I'm thinking of the Waffle House down there, multiple primary uses, they had to come in for a variance.
Yeah, well, its use is commercial. So just like with any multi-tenant commercial building, it's each lease space has their own use. I would recommend that if you grant the petition that you limit the effect of your decision to the area leased by the petitioner, so as to clearly state what you're doing.
So not to the entire building.
Not to the entire building. That's correct. That's what I would recommend, because that's really, I think, what you're being asked to do. And you could just use the phrase, the leased premises, whatever the petitioner is leasing, as the way to limit the effectiveness and be specific about it.
How would that then, going forward, say this, we would grant the variance, but then the current lessors they move on. A variance lives on for that property, right? Because it's not tied to the business, it's tied to that property.
Correct. So other commercial uses could be, could occupy the same lease space in the industrial district. This is unusual in that it's a less intensive use.
Yeah.
Usually we're dealing with the other way around, like it's childcare in a residential district, a more intense use, a commercial use in a less intensive district. I think that Paul did a good job, though. I think the unusual language about childcare not being permitted as a primary use in an industrial sector is simply because what was envisioned was an in-house childcare center like at Harlan or like at some facility like that. But the truth is that most childcare providers are separate. And so if this were in a commercial district anywhere along US 236, US 36, we wouldn't be having the conversation just because it's tucked back there in that industrial district is why we're having it. And so you would be changing the use, but you'd be allowing a less intensive use in a more intense zoning district, which would tend to be a much different thing than allowing a more intense use in a lower intense district.
Thank you.
Do I understand the history correctly that there appeared to be some confusion about who controlled the property? And the petitioners were given information that was incorrect about where they needed to get their,
So they contacted our office. When the address was put into Beacon, it came up as almost like a leased parcel, not the actual ownership parcel. And when you go into Beacon and you punch in the address, it says Town of Avon if it's in the town. This did not.
and
So
is part of that because there was confusion with the
address
proper
to the
address
Not
labeling?
well, the address to the parcel is different than the address to the lease space. And the address to the lease space happened to be a weird parcel in Beacon
Okay,
that almost shouldn't have come up, but it did. And they were told they were not in Avon. And then they contacted Hendricks County and they said, well, you don't need anything from us. And so they thought they were good.
so
But
they
it
were
wasn't-
given incorrect information, thinking they needed to, that they were good to go.
Correct.
And then later it was discovered that they were in the town of Avon after the
Correct.
complaint was made.
Correct.
Okay, so they were relying on good faith. They were in good faith.
They tried to do the right thing and
Yes,
were
but
given
we're
bad
given bad
information.
information.
Yes.
Okay, okay.
Yeah, and I agree with Paul's analysis on the unnecessary hardship, which is a very high standard to meet. The definition of that is that strict compliance with the ordinance would leave them unable to use their property. And again, the chronology here, given advice, they relied upon that advice. They entered into a lease, although they're not operating though. They now have a hardship, and we helped create that. We did. And so it's a little different than what you hear about sometimes, but I think this happens occasionally. It's sometimes someone in the building department, sometimes planning, sometimes it's someone at the front desk. You never know how it's going to work. But
Right.
so this is a very unique case in that they articulate a very cogent, unnecessary hardship, make that argument pretty well.
That's where I was going in thinking through the whole, how everything happened, but I just wanted to confirm that what I thought I heard is actually what I heard, so.
Is that it for staff? We're right here from petitioner.
For the record, I'm Andy Cole, Coleman Office at 71 West Marion Street in Danville.
Well,
All right,
if you insist.
Gotta get it on the record.
All right, thank you. I am here representing your petitioner, Bright Star Academy Ministry, Inc. I have with me in the center there, the young lady is Faith Miller. She's the owner, operator of the daycare facility. She's got her parents, Rhonda and Antoine, with her this evening. As you know, request for approval of a use variance to operate a child daycare in an I-2. I'll just give you a little bit of background on
the daycare operation. Ms. Miller started her daycare in 2023 as an in-home daycare. There's various levels, from what I can gather, about 5 with the state, and she was at an in-home daycare. Began with 3 kids, fluctuates, throughout the year, but at a maximum at one point she had about 13. So getting pretty busy for the home site. Decided to look for an off-site property. December of 2023, or toward the end of 2023, and then all of 2024, looking for a facility to operate from. Didn't have any luck. Found this lease opportunity, and I won't rehash I think you've gotten a pretty good indication of what happened here, and a little bit of miscommunication. And so they did, they started their thing and then found out about the violation. So here we are. In terms of Mr. Lambie mentioned the state process. They do have to be licensed by the state. They're waiting to file that application. They've been in contact, Ms. Miller has, constantly with the state, but there's a time frame on that once you file it. And so best course of action here is to seek the zoning first, because the state can't approve you if you don't have the zoning in place. Step 2 is the fire inspection. They attempted to have that done to keep things rolling, and they were told, we don't want to do the inspection until the zoning. So everything kind of hinges on this step 1. Then we would do the fire inspection if we're approved here this evening, and then move on to filing an application with the state. In terms of the proposed use, you're looking at hours of operation from 6:30 a.m. to 6 p.m. They have children, infants to 12 years old. In terms of any staff, this is regulated by the state. They have required background checks, fingerprinting, drug screening. There is a physical test through Indigo Urgent Care. Just to make sure that they can lift and do things that would be required in a daycare setting. So all of that is required. Ms. Miller is approved. I'm going to use the initials here, and I'll mention that. But CCDF, she was approved for vouchers from that program through the state at her in-home facility, and will continue that licensure through at this facility. And what that is the Child Care and Development Fund. It's a federal program. It helps low-income families pay for daycare while the parents are either going to school, going to training, or working. And it supplements so that they can pay for daycare during that. In Indiana, that program is administered by the Office of Early Childhood and Out-of-School Learning, which is part of the Family and Social Services Administration. There's various eligibility requirements for that program for the families that apply. There's a maximum income level threshold. There is a residency requirement. The family must reside in the county where the facility is. So this is going to be strictly Hendricks County folks using that program. Children must be under 13 years of age to apply. There's a citizenship requirement. The child must be a U.S. citizen or a qualified legal alien. There's a proof of identity for all family members requirement. And then there's also an attendance requirement that the state monitors. So if these families are getting a certain level of funding to pay for daycare, it's expected that they're using that for daycare. And so the state monitors their attendance at the facility as well. The state involvement would be ongoing. Daycare facilities are regulated under Indiana Code 12-17.2. They do generally 2 site visits a year. One of those is scheduled and announced. The other is a pop-in. So they do come by at any time they choose. They'll be doing things like confirming that immunizations are up to date for the kids, confirming that periodic fire drills are occurring. They'll be looking at the kitchen facilities, or refrigerator, checking out the food situation, site sanitation. So there is an ongoing monitoring element with the state. So the CCDF program is going to directly benefit Avon residents and allow lower income residents to work or attend school or training and still have the ability to have daycare for their kids. At the same time, it's going to ensure that program ensures the state's continued involvement in monitoring the site. Ms. Miller has recently been in contact with Avon High School, and they're continuing those discussions. There is hope to set up an opportunity for upperclassmen to work at the facility for elective credits, depending on what their major is. So those discussions are ongoing, and hopefully there will be that opportunity for the town as well. I think I'll end here just showing some slides. So this is as you come in the front door, and this kind of hits on Mr. Lambie's comment about the character of the building being, not necessarily an industrial building that we would normally think of. So this is when you come in the front door. There we go. Here is the meeting room for staff. There's the kitchen. There's one of the rooms, obviously the infants. Another room. There's a larger area. We'll get some tables and chairs in there. They do a lot of educational, I guess that was it, a lot of educational work there. I think you had probably some letters in your packets. I think you could see in there that the parents were very happy with the level of instruction the kids get. And there's also, this is a ministry for them, so there's a faith-based component to it as well. One thing I would just reiterate is that the child care use in general is, as has been mentioned, it's not a prohibited use in the I-2. It can be a permitted use. So there is a contemplation that could be accommodated in the district. And also, if you look at some of the permitted I-2 uses that could go in as a matter of right in the I-2, you do have schools, you've got community centers, you've got parks, playgrounds. All of those are actually permitted uses in the I-2. And so there's definitely an anticipation or a contemplation that you're going to have kid-centered activities at times in that district. Back to the support letters, I think you could see the parents are very pleased with Bright Star Academy. There was a common theme across all of those letters. I noticed that my children are antsy to get there in the morning and excited as heck to be dropped off. And then when we pick them up, they don't stop talking about the place and what they did. I think as parents or grandparents, that's hitting a home run if you're talking about a daycare facility. So they do a very good job. We are pleased to be here with a favorable staff recommendation, and we would respectfully request your approval this evening, and we'll answer questions you might have.
So are they currently operating in the space?
Right now they're not. They were advised by the state that they could transfer kids from the in-home. They could not seek new CCDF children. And so they were operating with some of their clients that they already had. They have not sought new children.
So they are operating in the space. They're just not taking on new students.
Yes.
Okay, but they are currently operating in the space.
Yes.
Under the licensure, under the the licensure they had from the
Yes.
previous.
Yes.
Okay.
That's correct.
Okay.
Before we go any further,
Oh, I'm sorry. Go ahead.
as I said, before we go any further, let's go ahead and open up the public hearing. Is there anyone signed up to speak? Is there anyone who wishes to speak?
Well, we put her on there in case she's needed for something I can't answer. You want to ask her how tall she is or something?
Last chance if anyone wishes to speak. No one coming forward, we'll close the public hearing. I'm sorry, continue.
Okay, sorry about that. I just wanted to get, because I wasn't clear based on staff's reports whether or not they were actually in the hearing, in this space or not, but they are functioning in this space. They're not just they're just
Pretty
not
limited,
taking
yeah.
new
Yeah.
children until they get the licensing approved, which is dependent upon the exception and
Yeah.
all the inspections and everything.
Yeah.
Okay.
Can you talk to what the state does to certify? And do they certify the location? Is it just the program? What is a state certification that's necessary?
I'm going to bring Ms. Miller up to answer that, but the question made me think of something that was discussed already. I'm going to just offer my 2 cents on it. In terms of I agree that if there were condition put on the leased premises itself, it's approximately 3,700 square feet, give or take, but the leased premises would make sense. The other thought I had was that this is a tenant space. This is not sometimes when you have a use variance for a separate building that's being used by the owner, to your point earlier, you would see that use variance run with the land. I think in a landlord-tenant situation, and Mr. Taylor could speak to this, but my thought is that could be conditioned on the applicant, because once that tenancy is done, the landlord's going to be seeking new tenants, and I think in that situation, it could be appropriate to limit it. As I say, my 2 cents, but if that was a desire of the board.
So I understand, and I'll look at council here, because before I thought we couldn't limit it to petitioners, that any action stayed with the property, not with the petitioner.
Yes, that's been what we've always done. And I think that we can accomplish close to the same thing. But I mean, if this tenant left and someone moved in and wanted to do childcare there, I would assume if we approved the variance of use the first time, we would have no real trouble. One of the unique factors of this case, and the petitioners hit on it pretty hard, is this is a highly regulated business.
It is.
And so because of that, if a different tenant moved in to operate childcare, the town would kind of know what to expect, because it is very highly regulated. Good luck. But they do approve the facility, and they do approve the operations and health, and it's very, very, it's demanding, and for good reason. We're dealing with children, it's for good reason, but it's a difficult thing. If you can get your approvals, then we would know what to expect, as opposed to if this were a auto repair shop, for example, and they move out, you don't know what you get exactly. But I think that I would just want a condition to be that it's limited to the leased premises, whatever the petitioner is leasing. And that's the way I think is the best way to approach it. And then we don't have any problems in the future. I would rather maybe not go quite so far, because I really don't want it to be challenged. We don't have any reason to go that far. I think we can do what we want to do.
If we would grant the variance, this just adds another use, and all the other uses in I-2 are still available to any future owners or people that would come in and potentially lease that if this business would move on.
Correct. It's a good point. The effect of an approval would be to simply, really, essentially say that this particular use, the child care center, is now permitted as a primary use. Doesn't have to be an accessory use to something else. That's what you're really doing here, and that's all you're doing.
All right.
So my question is for transportation. And so this is a pickup, drop-off, pickup kind of situation with parents or guardians or whomever. Are there often the schools get involved? Because you have before and after here. So are there buses that come? Will we see any other traffic besides just, regular car traffic, here?
Do you want to answer? Yeah, come on up.
Yeah, I'm just.
That's one I didn't ask.
Is that
I'm going to be curious to the answer, just like you.
I'll leave it to me to ask.
Go ahead and give your name and address.
Okay, okay. Wait, the building address or my actual?
Whichever one you want on the public record.
Okay. Okay, hi. Okay. Hi, my name is Faith Miller. My address is 2137 Foxglove Drive, Avon, Indiana. Um,
Buses.
About the buses. So right now, we are only serving kids under 6 right now. We hopefully to get kids in before and after school. That's why we wanted to do that. But right now, we're only serving kids under 6 years old. So right now, that is not a thing that we need. However, the license that I am trying to get, which is ministry, we are trying to limit that because, what else do I say? I don't know what else to say. Because we're trying to limit that because they don't really need, because most of our parents right now are usually teachers or doctors, and they usually get off at like 4 or 5:30 or like right before school gets out. So we don't really need that at the moment.
In the future, going forward.
Yes.
Get new people.
Yes.
New kids, and that's what you want to grow your business.
Yes.
So you want to take older children.
Yes, correct.
I read in somewhere that like up to, what was it?
12 years old. Yes.
Okay, so obviously they go to school. Or
Yes.
They do. So that might necessitate, you know what I'm saying?
Yes.
I'm just wondering if that would, I guess, I'm trying to think if that would impede anything in that location or. if that would
I
affect- I don't know that it would affect you going there.
Yeah.
I'm just wondering about what's around there and how that might.
I don't think that it would. I don't think that it would affect it because the buses that we would have, it's like more of a short bus. It's not like a really big bus. And if we do take before and after school kids, they would get there at 6. We would drop them off and the bus will be parked right there in the front. So it wouldn't take up any space that is used right now.
Sometimes they idle or.
Yeah.
You might get the wild bus driver with the tunes going.
Oh, no.
I've seen it.
Yeah.
But anyway, I just was curious.
Okay.
I don't recall exactly the space there, so the traffic pattern, like, do they?
So if you get to the south end where they're located at the south end of production, as was mentioned, it then veers west toward the Harlan and there's a very large parking lot right at the end. So they would turn around there. Yeah. Yeah. And it's not a through lane, so you don't have traffic coming from the other. Thank you.
Can I ask Faith a question?
Yes.
How many seats do you anticipate your capacity to be?
For the entire building is 30. So we do ratio. So basically, with CCDF, you have to have a ratio of each teacher, each kid in each classroom. So with our infants, we only are going to do like 4 infants. That means it's only 1 teacher in that classroom with those infants. So it's a ratio base.
Okay.
So we only want a capacity of 30 kids.
I do have one question if you wouldn't leave. You might be able to help here. When I first saw this location, knowing that location, I was a little surprised, but then I think staff did a good job of pointing out there could be a secondary use for like a Harlan bakery. So I thought, okay, this is, I don't know daycares. I'm assuming that's what the state works with you on, making sure that it's safe and usable, and you got to meet all those requirements. And I've used a daycare for children, but I've never run one. So I applaud you for doing that to take care of kids, because that's a heavy duty there. So that, can you help me? Is the state really is the one that's going to make sure and look at everything in that location that it meets the requirements for safety of the teachers and the kids?
Yes, so with it is that the state is going to be an ongoing process with us. So that means that they would do like an initial inspection. And with the initial inspection, they want to make sure that the building is safe. Obviously, like we have like the sinks, we have the child-approved furniture for the kids, and that all of our employees, staff and records are up to date, like our TBS test, our physicals, things like that, that we have to do. And we also have to go through a thing where we have to take tests, like each week or month, we have to take a test, like different things, just to keep we being refreshed on things that we do. So it is more like they are like really in it, you know what I mean, with us. So it's not like they just like, oh, tell us like, oh yeah, you have a child care, you're on your own. Like they really walk us through the process and help us make sure that we're getting more kids, make sure that we're in standard with state, with child safety, and making sure that they're okay.
Okay, thank you.
You're welcome.
I have another question. Just for meanness.
Okay.
Not really. So do you chat with the state environmental folks at all? And basically what I'm asking, not so much what you're doing, but you said are people around and whatnot, you know, you have to dispose of stuff. And so I'm just wondering, is that an inspection that they do, or is there something that, have you not crossed that bridge, or is that?
No, that's
something that doesn't even apply?
that's something that doesn't even apply.
I mean, some things they're outside for
Mhm.
recess.
Yes.
And next thing you know, got something going on, so because of what one of your neighbors is
Yeah.
doing, so I don't know. I don't
Yes,
know
no,
what it would be.
yeah, no, that doesn't apply at all. What they are looking for is making sure that the kids are safe. And if the kids are safe and like everything is checking out on their boxes, then they're good with us. So it's never been that. So, yeah.
So that what I'm alluding to basically falls under the ceiling of safety.
Yes,
I think is what I'm hearing you say.
yes.
Hold up, don't go too far. You know.
I know that I'm seeing with Family Promise, we're doing a venture with the industrial park in Plainfield, and we're going to have early learning center there, right in an industrial park. And that is a trend to service the industrial park areas for kids. So I can see the need and the value of having it in an industrial park.
They actually do have one client right now who works there in the park. So over time, that may expand for that need. And to your point on that, I think that goes to the whole issue of safety and with the state involved and doing pop-ins and that type of thing. The goal is make sure the kids are not unsafe. So as long as the regulations can be met, it can be accommodated.
Any other discussion?
Thank you.
I'll just say, I'll just add, I thought the staff report was spot on. Criteria 1 for safety. Typically, when I look at stuff like this, I'm looking for conflicts between peak traffic periods when you're mixing the truck and the car traffic, but I really don't see that being an issue here. The truck traffic, I'm not going to claim to be an expert here, but it's pretty constant in and out of there, so I don't see any big conflicts there. So
I like the idea of adding more daycare opportunities. I think other than housing, the biggest challenge families have right now is finding affordable daycare. You know, when you're paying more for daycare than you are for your mortgage or your rent, you know, and that's not just specific to Avon, but it's everywhere in the country. Daycare is just extraordinarily expensive. So the more options we are able to provide the members of our community, the better. And it sounds like the petitioner has done everything she can to cross her T's and dot her I's and do things the way they're supposed to be done by the state. And apparently her children's parents are very happy too. So.
I was just gonna say that, I'm gonna comment that at least by the 6 letters or so, it sounded like they're very happy. that the kids are happy, but they're happy,
Yeah.
you know, happy parents make your life a lot easier, I'm sure. So congratulations on it.
So I have a question for staff then. Is the correct address the 137 Production Drive?
Yes.
Okay.
I guess the other thing I'd say is I'm supportive of Dan's recommendation to, correct me if I'm wrong here, Dan, limit the variance to the leased premises.
I would say to the petitioner's leased premises.
Okay. Any other discussion? If there's none, we'll entertain a motion.
I'll make a motion. I move that we approve VRU 25-02, 137 Production Drive Childcare, a variance of use of UDO 3.2 to provide for a childcare use as a primary use in an I2 district because it will meet all the requirements for a variance of use under state law and subject to the adopted findings of fact with the condition that the variance of use applies specifically to the petitioner's leased premises.
I'll second that motion.
A motion by Mr. Guckenberger, a second by Mrs. Ransberg. Is there any discussion? Roll call vote, please.
Guckenberger,
4.
Inman. 4. Ransberg,
4.
Tashler,
4.
Turner.
4.
Yay.
Thank you.
Good luck.
Do we have any other business?
I just want to make another note that you received an email from me earlier regarding this training that's being completed. I know Paul and Catherine have already heard about it, but it is free for us and for this board. Paul and I are going, several members of the Plan Commission are going. And if you'd like to sign up, there's a link in the email that you were sent today, and you do have to register, but it is free.
I'm registered. Initially, I thought it was mandatory. So I was like, I can't.
It is not mandatory. It's just a day of learning.
The school night. Are they doing that? Anyway.
Okay, if there's no other business, we are adjourned. Thank you.